The League of Women Voters is proud to be a support group in the electoral process. All across America, at the local, state, and national levels, the League is the one nonpartisan organization that consistently works to promote good government and encourages citizens to become informed and to vote. If you would like to become a part of this team, we'll be happy to have you become a member. You can find a membership form at the table as you're leaving the forums this evening. Thanks to the League members who are helping out here this evening. It makes our work easier when all of us participate. Our special thanks go to the president of Southwestern Michigan, David Matthews, who has arranged for us to use this wonderful facility. Now, it is my pleasure to introduce our moderator for the forum on the 43rd Circuit Court here in Cass County. She is Mary Drolette, a lifelong resident of Niles, an attorney, and for many years has been Deputy Director of Legal Aid of Western Michigan. Mary also volunteers in many local service organizations. She will be our guide through tonight's debate. Mary?
Thank you for the introduction, Chris. Welcome to this debate featuring the candidates for judge for the 43rd Circuit Court, which is located here in Cass County. As Chris said, I will be the moderator for the debate, asking questions to the candidates provided by the League. Everyone in this room knows that good government does not just happen, and that important and essential component of our government is the judiciary. On November 8, Cass County area voters choose which person seated here will become the next Cass County Circuit Court judge. The Michigan Constitution requires members of each branch of government to swear or affirm that they will support the Constitution of the United States and the Constitution of this state, and that he or she will faithfully discharge the duties of that office to which he or she has been elected according to the best of his abilities or her abilities. Excuse me. The purpose of this forum is to help you, the voters, decide which of these two candidates will be better able to discharge the important responsibilities of judicial office in Cass County. Each of the candidates in this debate, and the one which will follow immediately afterwards, have agreed to follow a few basic rules. We will begin the program this evening with 2 minutes of opening remarks from each candidate. Then, as moderator, I will ask each candidate the same questions prepared by the League of Women Voters. There will be no questions from the audience. Both of the candidates have affirmed that they have not seen or otherwise learned of the questions before them tonight. There will be no rebuttal, although the moderator is permitted to ask a few follow-up questions. The candidates will have a set amount of time, 2 minutes, to answer each question. When we have finished with the questions, each candidate will give a 2-minute concluding statement. Our timers for this evening are League leaders, Christine Zilke and Karen Ristaw. They will hold up a yellow paddle when 30 seconds of answer time remains, and a red paddle when the time is up. So keep your eye on them.
And then you'll raise a paddle if we can.
We ask the candidates to observe these rules and to stop talking when they see the red paddle. Neither candidate is obligated to use all of the time allotted in the rules. We also ask the audience to listen silently and respectfully and refrain from any demonstrations of enthusiasm for candidates or their answers to any of the questions. We can give them all a round of applause at the end, as indeed anyone willing to run for office and serve deserves our thanks. We will begin the 2-minute opening statements with Mr. Herman, followed in alphabetical order by Mr. Teeter. Mr. Herman.
Thank you. It's a pleasure to be here tonight. For those of you that don't know me, I've been a licensed attorney for 34 years in the state of Michigan. I'm also licensed in the federal courts, and I'm also licensed in the Pokagon Potawatomi Tribal Court. My experience consists of 22 years' experience in prosecution. I have 5 years that I worked for the Cass County Prosecutor's Office, 7 years as the first prosecutor for the Pokagon Tribal Courts, and 10 years as prosecutor for the village of Cassopolis. When I worked in the prosecutor's office in Cass, I handled all kinds of cases from district court, probate court, circuit court, also handled appeals, handled murder cases in the Michigan Supreme Court as well as the Court of Appeals. In the last 12 years, and what I believe is important for a judge, not only to have that prosecution experience, but I also have criminal defense work, domestic relations work, which includes divorce, custody support work, real estate work, civil lawsuits, personal injury cases, contract cases, municipal law, along with a lot of other matters. I'm also currently the attorney for the Pokagon Ethics Board, and so I still serve in the capacity with the Pokagons. In the years that I worked in the court system, I've worked for 3 judges. I worked for Judge Dodge as his first law clerk for about a year and a half, and then from there I worked actually with then prosecutor Dobrich. I went into the prosecutor's office. From there I went into with Judge Phillipson and Judge Dobrich and was their administrator and their hearing officer. I conducted over 10,000 court hearings as an administrator and hearing officer for the courts, so I have a lot of courtroom experience. I also have a lot of volunteer work in the community, Rotary, I'm on the Mental Health Board, Dowagiac Fine Arts Board, Chamber Board, and I spent 14 years as the head of the Cass County Youth Council, where we raised hundreds of thousands of dollars and distributed in this community to a lot of organizations.
Thank you. Mr. Teeter.
Thank you. The Cass County Court has a proud legacy. Judge Dodge has been our circuit judge for 34 years, the longest sitting circuit judge in our county's history, and he has served with honor and with distinction. If you look at the former prosecutors in our county, Bill Grimmer went to the federal prosecution and retired there after 25 years of outstanding service in the South Bend system. Judge Dobrich was an elected prosecutor, went to our probate court bench, and has been recognized as a statewide leader in protecting children. Margaret Chiara was my predecessor. She actually was elected, the first woman to be elected to head the Prosecuting Attorneys Association of Michigan, and served with honor in that position. Vic Fitz, as my successor, has also served as the president of that association, and I had the opportunity to serve on that board of directors for 6 years while I was your elected prosecutor. In addition to that, I was appointed to a governor's task force on child support, which actually led to me leaving the county to work in Lansing. I still live here, have lived here the whole time, but I had the opportunity to go to Lansing and to start a division for the Attorney General's office unlike any in the United States. That division has now collected $201 million for over 15,000 Michigan children. And so if you look at that legacy and the honor with which the people that you have selected have served this county, I would be honored to be the next person to serve as a circuit judge in this county.
Thank you. The first question is for Mr. Teeter. Describe appropriate judicial demeanor. Explain its importance in the judicial process.
Appropriate judicial demeanor. What I saw when I was your county prosecutor for 10 years, I practiced in front of Judge Dodge. That's what it looks like. And what I mean by that is that even in the times when I disagreed with him, I felt that he heard me out. He listened to both sides, and he rendered what he believed to be a fair and appropriate decision based on the law. You see, we catch people at the worst moments in their lives, whether it's a couple breaking up a marriage, whether it's fighting over the custody of their children, or a young person who's become involved in the criminal justice system, or a victim of sexual assault, or a victim and surviving family of a homicide. As your county prosecutor, I handled all of the biggest cases in this county. I handled every one of the murder trials. I handled all of the child sexual assault cases. You see people at their absolute worst. What they need from the bench is someone who's fair and who listens to both sides and then renders a fair verdict. They're not always going to agree with the decision, but at least if they believe you listened and you heard them out, they had their opportunity in court. They had their day, and they had the opportunity to sit there. I believe that we still, I believe, in a small community like ours, have a court system that believes in second chances. I've dealt with juvenile delinquents. I've dealt with young offenders. I've also stared evil in the face. I sent to prison a man who planned out, carried out the murder of his own 2-month-old child. That's evil. You have to, as a judge, be able to recognize the difference between those two and render a verdict and a sentence that it's appropriate for both, that doesn't crush the young person who made a mistake, but also respects the victim, because they can never be forgotten in the system. We owe both the best that the court can offer.
Thank you, Mr. Herman.
Thank you.
Same question.
Yes, I think judicial demeanor is dealing with fairness with the parties. I believe that as a judge from the bench, you need to respect the parties, you need to respect the litigants. I've been an attorney 34 years, and I've been in enough courtrooms where that's not the case. I worked for Judge Dodge the first year and a half that I was an attorney, and I spent time in court with him, and I would have to indicate that having worked with him, the man has a wonderful demeanor. He treats litigants fairly. I've learned that. He's always prepared when he goes in the courtroom, and I believe that's important. And I believe you need to make sure that the litigants themselves are treated with respect, regardless of whether they're a defendant, regardless of whether you agree with their position or their side. I think it's important that people feel that when they're in court that they do have a fair chance, and that the judge is going to listen to their case, and the judge is going to make a decision based on the facts and not based on prejudices or biases. And I think that that's what good judicial demeanor is. As a hearing officer, I've conducted over 10,000 court hearings, and I had a lot of attorneys ask me to run for this position because of my demeanor and my judicial integrity. Many of the attorneys came to me and said they have appeared in front of me many, many, many times in court, and they believed that I treated them fairly, that I treated their parties or their litigants fairly, and they always felt like they had a fair chance when they were in court with me. And I think if you were to talk to attorneys in this community who have appeared in front of me, they will tell you that I have judicial demeanor very similar to Judge Dodge. Thank you.
Thank you. Next question is for Mr. Herman. What in particular, in your experience as a lawyer or otherwise, will best serve litigants who appear before you if you are elected?
What's that? The best?
Will best serve litigants
No, what was the first part of the question? Excuse me.
in your experience as a lawyer or otherwise?
Well, I think what's important that you need to realize and you bring to the bench is that, as attorneys, we, especially in private practice, when cases come in the door, you don't always get to pick the side that you want. You don't get to pick the good side or the bad side. You pick the party as they come into you. You have an obligation to serve them and to represent them under the law according to what the law is. It doesn't necessarily mean you always are on the right side. But I think as a judge, which is important too, is that you realize that everybody that's in front of you, that's the most important case in their life. I don't care if it's a murder case. That's obviously, I think, in the newspaper, that seems to be very important. But if parties are in court getting divorced, or if someone's in court on a jaywalking ticket, that is the most important case in their life. And that's something that needs to be addressed. And I think a judge needs to make sure that they treat those litigants with that respect so that they know, so that the parties know when they're in court that you also consider their cases very, very important. And as an attorney, when you handle a case, every time you're in court, your clients need to understand and appreciate that you believe that their case is the most important.
Thank you. Mr. Teeter, did you want me to repeat the question?
No, thank you. When you look at the experience, in particular my experience, I originally started as a defense attorney, and I was trained with, I'd argue, the best firm in this county at French and Lawrence at the time. And they taught me well, not only how to represent clients, but also to make sure that we were arguing for what was fair and what was appropriate when we went into court. Well, I left that when I joined a prosecuting attorney's office to represent the kids in child abuse neglect cases. I had done some of that work as an independent attorney. And I began to prosecute those cases because instead of doing them on 25% of my caseload, I got to defend those on 100% of my caseload. In addition to that, what most people don't realize is the job of prosecutor is unlike that of a private attorney. And what I mean by that is that part of my responsibility in representing the people of the state of Michigan, the defendant is one of those people. So when I'm in court, part of my responsibility is to make sure that the defendant receives a fair trial, that his constitutional rights have been protected, or hers, and that we have proven our case beyond a reasonable doubt based on our system. But at the same time, our responsibility is to make sure that the victim receives a fair trial. Private attorneys, a defense attorney does not have that dual responsibility. Their job is to represent their client. So the only two people in the courtroom who are charged with the responsibility of looking out for the defendant's rights and the victim's rights are the judge and the prosecutor. Well, I have spent 24 years in that capacity at every single level. Right now, I'm part of the largest law firm in the state, handling the biggest criminal cases in the state of Michigan. There is nothing our county will face that I haven't faced. The last case I handled had over 700 victims in one case. Last year, circuit court only had 500 felonies total. And I say that because if you haven't faced it, if you haven't tried a murder trial, then how do you sit over one as a judge? And I've tried numbers of them.
Next question, and Mr. Teeter goes first on this one. It is said, ours is a government of laws, not men. What does that phrase mean to you? How, if at all, is it relevant to the job of a judge? Do a judge's personal opinion have any role in the decision-making process?
This is a timely question in that there are folks in our society right now who are questioning the rule of law, whether or not our system actually works. One of the frustrations I have is that I believe in a strict construction of the Constitution like Justice Scalia. I believe that we had brilliant men who wrote up a Constitution that included a balance of power. We have a legislative branch, and unfortunately we've seen people from the bench who believe they're so much smarter than all the rest of us that with one signature can change the law in the United States, and I don't agree with that. But in addition to that, when you look at a personal opinion, first of all, it's not the judge of the job to legislate. It's the job of the judge to interpret the law. But then secondly, there is a significant amount of discretion, particularly in a circuit court case. As I mentioned earlier, you have to be able to sort out, is this a young person who needs some consequences for their actions, but you still leave them the opportunity to be rehabilitated and become a productive member of our society? Or is this someone who's going to endanger the lives of other people and I have to remove them? Well, I've done both. I've handled cases where kids have vandalized the Cassopolis public schools. Did that all the way up to the Hilltop Laundry shooting and the Becky Stowe homicide, where a young man planned out and then carried out the murder of his 15-year-old girlfriend. So I can tell you that when you look at that, there's a broad discretion that judges have to work with to be able to sort those positions out. Well, as a prosecutor, I don't just recommend the highest sentence that somebody's capable of getting. It's a recommendation to what is the right sentence to do. And again, that's been my responsibility for 24 years, and it's different than a responsibility of a private attorney representing a client.
Mr. Herman?
Yes, could you repeat the question, please?
It is said, ours is a government of laws, not men. What does that phrase mean to you? How, if at all, is it relevant to the job of a judge? Do a judge's personal opinions have any role in the decision-making process?
Well, the opinion of a judge doesn't have any real impact at the trial court level. Obviously, if you're at the Court of Appeals level or the Supreme Court, those are the levels where the justices or the judges use their opinion more. A trial court judge is supposed to interpret the law and enforce the law as it's set forth in statute and as it's set forth by the Court of Appeals and the Supreme Court of both this state and the United States. It's not our job to interpret the law. It's our job to enforce it. And so in that regard, a judge's opinion isn't important. A judge's opinion should not be important what their personal belief is. in how they would handle a given case, be it whether you believe that marijuana is legal or not legal, those kinds of issues. Those are issues to be decided by the Court of Appeals or the legislature. And when we say we're a system of laws, that's what we are. We have three branches of government. We've got an executive branch, judicial branch, and when the legislative branch, the third branch, passes something, we need to enforce those laws. We need to not ignore those laws. We need to enforce those laws as they're written, not as we believe they should be written or whether they should be ignored. Thank you.
Thank you. Next question, Mr. Herman will go first. If elected, are there any types of cases you would disqualify yourself from hearing? Explain why.
No. I mean, I can't imagine that there's any types of cases that I would disqualify myself for. I mean, again, and I think it kind of goes back to the last question. You know, we are a system of laws. We take an oath to enforce the laws, and so in any case that's brought before me, I'll do my duty as a judge and handle that case. Now, of course, if there are personal issues, you know, if it involves a family member or a prior partner or something like that, you may have to disqualify yourself. But there aren't any issues in and of themselves that I would disqualify myself for.
Thank you. Mr. Teeter.
There are ethics rules that govern when we're supposed to disqualify and when we're not. So if those come up, obviously we'd follow the judicial canons. In addition to that, though, there are certain types of cases I believe I have special expertise in. I'm a national trainer on domestic violence. I'm a national trainer on elder abuse and financial exploitation. So I believe that expertise, when I bring it to the bench, won't hurt me. In fact, it'll help me understand the types of cases that'll come before me in those areas. And so I don't have any areas that I know of that, unless, again, case by case, it's because of the people who are involved, that I'd have to disqualify, but not based on topic.
Thank you. Next question, Mr. Teeter will go first. Do you believe a judge has a special obligation to a litigant who appears before him or her pro se? If not, please explain why. Otherwise, please explain your understanding of the nature and extent of that obligation.
Regarding the special obligation, yes, I believe that there's a duty, and the case law is pretty clear about warning the consequences of appearing before the court pro se. In fact, I tried a racketeering case against a young lady who just vehemently demanded to represent herself. So both myself and the judge spent significant hours going over each phase of the case, each phase of the trial, what she would be required to do in giving an opening statement if she chose, questioning witnesses, admitting evidence, and then also arguing, cross-examining witnesses, and then closing argument. And so that way she would understand what the risks she was assuming, because, and again, repeatedly I said, I've been trying cases for 25 years. This is your first one. This may not be the one you want to learn on when you're facing a racketeering charge that carries a maximum penalty of 20 years in the state's prison. And the judge said the same thing. It's probably not a good idea to take on the Attorney General's office as your first case to learn how to try one, even for lawyers, let alone non-lawyers. So to that extent, you can't favor them, but you need to make sure to inform them, educate them, and warn them that the consequences could be severe. I tell people, I said, representing yourself is a little like doing surgery on yourself. If it doesn't go well, you have only one person to blame for the results. And sometimes they're equally cataclysmic. So you don't do that lightly, and I believe the case law spells it out very clearly, and like I said, I've been through it. And she chose to do so anyway, and she went to prison. So.
Same question.
Thank you. Pro se litigants, that's the one thing in our society. We have rights, and if you choose to represent yourself, you can do that. However, pro se litigants, obviously, I think a judge's job when you're dealing with pro se litigants, again, is to instruct them, to let them know of the problems they may face in handling themselves, but they do have a right to do it. A judge also has an obligation, not just to the pro se litigant, because I've handled cases against pro se litigants a number of times, and what the judge, I think, has an obligation to do is also to make sure that the proceeding does not become a circus for the other side also. Both sides have the right to have a fair trial, and the judge should not go overboard in protecting the rights of a pro se litigant. I think a judge has an obligation to explain to a litigant, but they also have, the person has that absolute right in our system to represent themselves. And I've seen some pro se litigants that actually have done a pretty good job because they may have a special expertise in an area and they may be well-trained and can present that to the court. But they also, the other problem that you have is there are rules of evidence, and just because you're a pro se litigant doesn't mean you can ignore those rules of evidence. And so a judge's job is to instruct them and to make sure that they understand what they're undertaking. And again, I think sometimes we see on television, you may see criminal defendants that want to represent themselves. Sometimes it's important that you actually appoint an attorney to be there so that they can have assistance if they need it. But if they choose to represent themselves, they have that right. You appoint an attorney that can be there in the courtroom with them, and they then can advise the litigant.
Thank you. Next question, Mr. Herman goes first. Explain the burden of proof and how it should affect the outcome of a trial.
Well, there's a number of burdens of proof. There's preponderance of the evidence, there's proof beyond a reasonable doubt, and there's clear and convincing evidence. It depends on what type of proceeding you're in. Obviously, I think we've all heard that proof beyond reasonable doubt is what there is in a criminal case. In many civil cases, it's a preponderance. You do get into some issues when you deal with changing custody where there needs to be clear and convincing evidence to change that. And also when you deal in the state system with adoptions and things of that nature, when you're dealing with, say, American Indian children, the court needs to make sure that those evidence standards are a little higher. Unfortunately, there's no magical checklist where you go 1, 2, 3, 4, 5, this is beyond reasonable doubt, this is beyond, this is clear and convincing, or this is preponderance. Theoretically, obviously, a preponderance is a little more on one side than the other. Clear and convincing is a little more than the preponderance, and then proof beyond a reasonable doubt is what we have in a criminal case. And proof beyond a reasonable doubt is that when you should have proof beyond a moral certainty that that an individual is guilty of an offense. And so there's no way to really explain it. I've been an attorney 34 years, though, and what I can tell you is with the experience that you have, you know and have an understanding when those burdens have been reached. And again, in the circuit court system, you have jury trials, and many times those burdens are placed on a jury, and they are instructed on what those burdens are, and they have to make those decisions.
Thank you. Mr. Teeter.
As Mark said, we have 3 different levels: preponderance, clear, convincing, and beyond a reasonable doubt. I've spent most of my career at the highest level of that. Preponderance is just that. It's a scale, that there's a little more on one side than there is on the other. And it often applies to civil cases. But again, our position and our responsibility as a judge is to instruct the jury clearly so that they can understand what their responsibility is, because it's a huge responsibility to sit in judgment of your fellow citizens. So the better we explain the rules, the more effective they're going to be at following them and then completing the task they're charged with. Again, clear and convincing evidence is slightly higher than that, and beyond a reasonable doubt. The jury instruction says it's a fair and honest doubt to which you can attach a reason based on the evidence and common sense. Sometimes I think we have this picture that that's beyond any doubt. That's not what the law requires. And so the instructions basically talk about and if you look at that in your life, there are many decisions that you make beyond reasonable doubt. And during voir dire, I used to ask those questions and still do when I'm questioning the jury. And that is, how many of you bought a car, or if you picked a college, or you bought a house, or you've gotten married, that you believe that at the time that you made that decision, that you were making the right decision beyond a reasonable doubt. If not, if you had all kinds of doubts to which you could attach a reason based on your reason and common sense, you probably wouldn't have done it. It's a little tough to do that with divorces, because now people go, well, at the time I was, and then I found out I was wrong. And but it's not magical. There is a clear formula for how to do that, and it really comes down to how well you explain it to a jury. when they have that responsibility, and then how well you apply it when you have that responsibility as the court.
Mr. Teeter goes first on this question. Does a judge have an obligation to assist a litigant who is not being adequately represented by legal counsel? And I'm assuming this is different than the pro se litigant. If not, why not? If so, what is the nature and extent of that assistance? Would it make a difference if the litigant is indigent and the attorney has been appointed to represent him or her?
Question is, does the court have an obligation to assist a litigant? And I guess I would phrase that somewhat differently. Does the court have the obligation to make sure that someone is adequately represented so that their rights have been protected? And the answer to that question is yes, particularly when it deals with indigent defense. That's a huge issue right now across the state of Michigan, including the Michigan Supreme Court, who adopted guidelines to make court-appointed counsel do what they're supposed to do so that an indigent client receives at least what we believe to be the minimal acceptable level of service. Well, those are implemented through the local court. The Supreme Court doesn't follow that. Our courts follow that. So I believe that you can, and not only have the opportunity, but the obligation to make sure that that's the case. And if you see someone, particularly again, who is indigent and is at court-appointed counsel, where counsel's clearly falling below the standard, I think you have an obligation to first of all, talk to the counsel with the other side present and say, do you understand that there is a minimal level that you have to hit? Otherwise, this case is going to come back on appeal because you have failed your client to the point they've not received the minimal level of representation required by law. At the same time, that's different than steering a case. I mean, frankly, if people come into court and they want to advocate positions that don't necessarily help them, they have the opportunity to do that. Our job is to make sure that minimal standard is met. And if it's not, yes, I believe the court has an appropriate role to supervise that.
Thank you. Mr. Herman.
Thank you. I think judges, and I think it's the way the question was asked, I don't think judges have an obligation and actually legally shouldn't assist litigants. You're there to either make a decision or you're there to instruct a jury, but you're not there to assist the litigants. I think you have a higher burden as a judge to watch out for the rights of a litigant if you have appointed the counsel for them, because obviously we want to make sure that their rights are protected. And again, if you see a situation in a court-appointed case where a person is not receiving adequate representation, I think a judge has an obligation to step in, stop the proceedings, bring it into chambers if necessary, and talk to them. And if there is a problem, you want to make sure that that's addressed. The other issue you have, if you don't have adequate representation, we've all heard probably of jeopardy attaching in cases, especially in a criminal case. You want to make sure that you're not in a situation where jeopardy is attached, and then you don't believe that there's been fair or adequate representation. So I think you have a burden, and I think as a judge to actually make sure that that person is represented, and if it means removing counsel and appointing new counsel, I think you have that obligation. In a retained counsel, I think it's a little different. I think there is a remedy when, if you've hired an attorney does a poor job and you lose, you can sue that attorney for malpractice. But I think as an attorney, as a judge, if an attorney, it's not your job as a judge to direct how an attorney handles their cases. And sometimes people have defenses or bring things to the attention of the court that you don't agree with or don't think necessarily have a lot of merit, but they have the right to bring those before the court. And so I think when you're dealing with retained counsel, then no.
Thank you. This question may go back to one of the previous ones, but Mr. Herman, go first. There are an increasing number of litigants representing themselves in court proceedings. I know, especially in the family law area, high percentages are representing themselves. How do you address this as a judge? How, if at all, would it affect a case before you?
Well, again, and when you mention the family law area, I think that's probably the biggest area where you're seeing it now, and it's probably when I've had pro se cases against litigants, it's been in the family area, especially when you're dealing with kids. People, I think, when they're dealing with their children, believe that they know what's best. Again, as a judge, I think it goes back to one of the prior questions. You have an obligation to instruct that individual what they are undertaking when they undertake to represent themselves. And if they choose to do that, that's fine. But there are still rules of evidence that need to be followed, because it's unfair to place a burden on one side and then ignore the burden on the other. So I think that a judge has the, must instruct that person, but to give that person an opportunity to address a case in court if they wish. It's hard to say, because a judge does not want, you don't want to, as a judge, get into the case itself, because you are the one that's going to have to make the decision in that case. You shouldn't direct them. You shouldn't tell them how to get evidence in. You shouldn't tell them how they should be questioning the witness. But you need to instruct them of the burdens that they're getting themselves into, and they need to address it.
Thank you, Mr. Teeter.
Well, I think there's two areas that you can address. The first one is, again, while you're in court, to inform and to educate, to educate people about what the risks are. And again, I believe it's appropriate to apply the rules of evidence and maintain the decorum of the courtroom appropriately. But I think secondly, from that outside the courtroom, off the bench, one of the things that judges can do, and I believe should do, is to assist in making legal services more available. Their folks don't go into court because they really don't want a lawyer. It's because they can't afford one. And when lawyers are charging anywhere from $250 to $650 an hour for most people, that puts them out of range. And so legal aid and there are other organizations in our state, access to justice funds, where the judges can take a leadership role and say, you know what, let's see if we can't dig deeper to deal with the underlying cause of that problem, which is to make legal services more accessible, support legal clinics, support legal aid, help push those kind of programs in the public so that we can stop putting people in a box and going, well, good luck, go in there and hope it works out for you.
Thank you.
I need to raise my fees. I don't charge even at the low end there.
Okay, Mr. Teeter goes first on this one, and it's a pretty broad question. Do you believe the law should be fairly administered? What is the duty of a judge to ensure that it is?
I think there's only one answer for this. If not, one of us should step down. Of course it should be fairly administered, and I believe Mark believes exactly the same thing. Again, when you walk into court and you take that bench, and I've done it as a prosecutor for decades now, you're dealing with people at their worst. At least you have the opportunity when you step into a court, at least in our system, that you believe that you're going to be heard, that you have an opportunity to have your say, and that you expect the judge to listen. Doesn't mean you're always going to win. Doesn't mean you're always going to get your way, whether that's a prosecutor or a defense attorney or a pro se defendant. But at least you should walk out with the feeling of going, you know what, I think he at least heard me, considered what I said, and then made a decision. And again, we've had a good model of that. For 34 years, Judge Dodge did exactly that. Well, I've been in courts all across the state of Michigan with the Attorney General's office, literally all the way up the west side, across the north, and then down the east. And I can tell you that you don't get that feeling in all of those courts. I've been in Wayne County. I've sat there for 2.5 hours waiting for a judge to show up for work, and then have them walk into the courtroom carrying shopping bags while the people before them sat there paying their lawyer, again, $250 to $650 an hour so that I could go shopping on their time. No, they have a right to have the law applied fairly, and for the judge to model it, to set an example in that courtroom that when work begins, it's time to go to work.
Thank you, Mr. Herman.
Yeah, and again, I think it's a fairly simple question. Yes, the law needs to be fairly administered. Doesn't matter whether you're young, old, black, Muslim, it doesn't matter. Everyone is entitled to protections under our system, and it needs to be fairly administered to all. And the question, so I think, is pretty simple.
Okay, next question, Mr. Herman is first. If you are elected judge, will you, as part of your regular case management procedures, require or encourage parties to engage in alternative dispute resolution efforts such as mediation? If so, in what types of cases? If not, why not?
Actually, I think in many cases, alternative dispute resolution is appropriate. Obviously, it works well in the domestic area when you're dealing with custody issues, visitation issues, property issues. Matter of fact, many courts are requiring that the parties go to mediation. It works well in civil cases also, and then there are cases, obviously, you can't have mediation in a criminal case, obviously, because there's not much room to wiggle there. But I believe that when parties are involved in alternative dispute resolution, when they reach a decision, they're happy with it or happier with it. Normally, when parties settle a case, nobody is 100% happy. Nobody's happy in a divorce case when you split up property, when you have to spend some time away from your children. But if the parties can sit down and reach an agreement, they have I think, more respect for the system because they've obtained a result which they can live with, short of going into court. If you go into court and you throw yourself on the mercy of the court, it may be neither of the parties come out happy. They may both come out unhappy. And so I think alternative dispute resolution is something that's very important and should be used and probably expanded. Absolutely.
Thank you, Mr. Teeter.
Well, I disagree with Mark on one thing, that everybody leaves unhappy in those situations where they litigate. The lawyers always leave happy. The more you fight, the more they make. And I don't mean that as a joke, because it's not. When you're playing with people's lives and you're billing $500 an hour, you don't have any incentive to settle. So I think it's really important for the judge to not force, but certainly encourage the parties to talk. I think it starts with discovery. I don't agree with playing games with hiding what evidence we're going to present from what evidence you're going to present, because the more the other side knows, the better you can evaluate the case. Mediation is often very helpful for that. They prepare briefs, attach evidence, submit it in so that the other side can see where we're really headed if we litigate this case. In addition to that, when you start getting people at least to talk instead of fight, what they find is maybe their differences aren't as great, that the difference between the lawyers are really great. And that, I think, is something that the judge can play an active part in sitting the lawyers down and going, look, tell me why we're not talking. Tell me why we're not exchanging evidence. Tell me why we're not working on resolving this case. And statistically, 90 to 95% of the cases do get settled. The problem is they don't get settled until the day before trial because we've had maximum billing. That's unfortunate. And the problem is that it's the Sherman's march to Atlanta. I mean, by the time you get done, you look behind you and everything is burnt and and destroyed. Those are people's lives. This isn't a game. And so when you walk out, part of our responsibility as lawyers is to hopefully leave it somewhat better than what you found it. And I'm not sure that we all understand that rule.
Thank you. That concludes the time we've allowed for questioning. We will now have each of the candidates give 2 minutes of closing remarks, beginning with Mr. Teeter.
Well, thank you. The two things I learned when I practiced before Judge Dodge is that I believe that every time he walked into the courtroom, he was the best qualified, best informed lawyer in the courtroom. That's why I've spent my entire career trying to become the best lawyer I could become. When I've worked with the Attorney General's office, it's been at the biggest, best law firm with the best lawyers in the state to become the best lawyer I could become. Secondly is that when he took the bench, he listened. And I've told this story, but the reason why the child support program got started, the felony prosecution program, is because I sat with a 16-year-old kid that I was prosecuting for stealing a stereo out of a truck. And during that contact, he said, there's the prosecutor, the sheriff, the judge, all of these people were lined up on my case for a $200 stereo. And I said, yeah. He goes, then can I ask you a question? He said, my dad owes my mom $35,000 in back child support. How many people are working on his case? And I gave him my word that by that afternoon there'd be a number of them. And over the next 4 years, I prosecuted 250 cases in this county, collected $1 million, and his dad was one of those people. I then went to the Attorney General's office to collect $201 million for over 15,000 Michigan kids and to change the culture of child support. Our goal was to make it like drunk driving. It used to be a joke to see how drunk you could get at an office party and make it home. It's not a joke anymore. It used to be a joke to laugh about how much you were sticking it to your ex and not paying to take care of your kids. In Michigan, it's not a joke anymore. And so I believe those two qualities, the best lawyer and one that listens, is how I hope to serve you as your next circuit judge.
Thank you. Mr. Herman.
Thank you. I distinguished myself, I think, from my opponent in a number of ways. Number one, I've worked for 3 different judges. And again, I think it's important, and any of you that are involved in the system realize, I know Tom does, judges, if you ever go to a dinner, judges sit together. You don't ever see judges dispersed. I worked for Judge Dodge. If I hadn't been qualified and competent as his law clerk, I would have never ended up in the prosecutor's office with then prosecutor Susan Dobrich. If I had not been qualified and competent in the prosecutor's office, I would have never ended up working for Judge Phillipson as his court administrator and his referee. And if I had not been qualified and competent as Judge Phillipson's administrator and referee, I would not have been retained by Judge Dobrich to do those positions. So I think it's important when you look at someone having qualifications, realize I've worked for 3 judges, and 3 judges in this community, and one of the judges who we're talking about, Judge Dodge, who is a wonderful man and a wonderful mentor and a wonderful judge, he obviously recommended me when I moved on into the prosecutor's office. The other thing I think that's important is when you have someone step into a courtroom, I've conducted over 10,000 court hearings. I've ruled on evidence. I've questioned witnesses. And I think it's important to have somebody that has courtroom experience. You can try hundreds and hundreds of cases, and I have, but it's different when you're sitting on the bench and you're making decisions. And so I think it's important to look at that. The last thing that I think is important is in this community, for the last 30 years of my life, I have done lots and lots of community service here in this community. I have raised money. I have for many programs, from the Parks Departments, from the Council on Aging, to the prosecutor's office. We gave money actually to Scott's office when they were there, to DHS. We gave lots and lots of money in this community. I do a lot of volunteer work for the Council on Aging, and I believe it's important not to just live in a community, but to give back to a community.
Thank you. Now, time for a round of applause for each of the candidates here.